Time on 103.1. It is now 11:31. So a lot talk about the latest bill, and this is a trending topic now. The Civil Asset Recovery and Management and Unexplained Wealth Bill 2019. Bill was passed in the House of Representatives on Monday night, and it's been a trending topic ever since. Some in praise of this, and some still dubious about the legislation. National Security Minister Stuart Young says they're satisfied, and he believes that the citizens can actually take comfort in this legislation being used in the government's fight against crime. How do you feel about this? This is what we were asking all morning on Sargam. So we have with us joining us this morning attorney at law Ronnie Bissessar, and this is a special interview this morning. Thank you, Mr. Bissessar, for making the time for us today.
Much for inviting me.
Okay, so in a nutshell, can you just simplify this bill and the objective?
Certainly. The purpose of the bill, and incidentally, the bill has a very long title, but I'm referring to it, as most people are, as simply the Wealth Bill. And the principal purpose of the Wealth Bill is to recover wealth which has been accrued through criminal activity. And for these purposes, the bill makes provision for the appointment of an agency, and that agency will be, in effect, responding to the DPP, and the agency will, in effect, make inquiries of and suggest that investigations be conducted in relation to the assets of specific individuals to determine whether or not any assets, well, wealth, which is identified, was derived from criminal activity. And if the answer or if the recommendation is yes, then that agency goes to the court with a request that an order for the assets to be forfeited. So forfeiture is not an automatic provision. It follows that after investigation, and assuming that the DPP is satisfied that there is, in fact, a prima facie case for the recovery of assets, the matter goes before a High Court judge who has a determination to make as to whether or not, in fact, these assets or the wealth is derived from criminal activity. And if a finding is made, then a direction is issued to the state to proceed to forfeit those assets which are directly or expressly derived from criminal activity. Does that assist, I hope?
Well, yes, it's much easier to work with now. I know it's a very long title, but it really does give us a better understanding. Joining me in studio as well, representing our newsroom, Sarah Chandu. Sarah obviously has some questions of her own.
Yes, thank you very much again, Mr. Bissessar, for joining us. I know a lot of the concern from citizens regarding this legislation comes from fear that it could be exploited. And in fact, the opposition and the government debated certain amendments to the original version of it. And that is what was passed in the lower house on Monday. Could you tell us more about that, the amendments that have been put in as quote-unquote safeguards with this legislation?
Certainly. Thank you, Sarah. It was passed unanimously by 34 votes in the lower house recently. But in relation to that, there were, in fact, I think, a total of 62 amendments which were proposed by the opposition, of which several of them were, in fact, accepted. The principal ones which were accepted and which form part of the bill is really, I think, three matters. The first one is to ensure that the bill deals only with certain specified offences. What I mean is that the issue of wealth derived from criminal activity is not referable to any criminal activity. It relates to specific offences which have been identified in the Proceeds of Crime Act, 2002 legislation, I believe, which covers a range of offences from things like racketeering, bribery, terrorism, corruption, and human and drug trafficking, as well as kidnapping and piracy. So the first point of the amendment, which was accepted by the government, was that it would relate a wealth which is forfeited must relate solely or specifically or directly to offences which have been identified in the Proceeds of Crime Act, which really speak to very serious offences of racketeering, bribery, and drug trafficking, etc. The second important point to make is that this bill has retroactive effect. Now, that's a very important consideration because generally retroactivity is only is very carefully circumscribed, but it means in effect that wealth which is derived from previous criminal conduct is now fair game for an application under the bill, well, when it is enacted. And for these purposes, the second principal amendment, which was accepted by the government, is for the provision of 3 agencies to be involved in the investigation. This was the Customs, the Police, and the Board of Inland Revenue. And the significance of the amendment is that previously the government had agreed to only having persons, if you like, representing these agencies. But one of the amendments is to ensure that the Comptroller of Customs, as well as the Board of Inland Revenue Chairman and the Commissioner of Police, in other words, the heads of these 3 important agencies form part of the investigating committee rather than any specific or any junior officers associated with any of these 3 agencies. The third point, which I think is important to bear in mind, is that there is an issue of privacy, which is one of the main issues that concerns, and I suspect, many of your listeners. And that right to privacy, which really means a right to respect for your private life, is now further protected because the government has accepted the opposition's suggestion that makes it compulsory that any document which was filed in court under this act be sealed and not easily or readily accessible or available to the general public. And that itself means that there is some level of secrecy associated with the application. But bearing in mind, of course, is that if the application to the High Court for forfeiture is in fact accepted and the court makes an order, that is now a public order. So while the application is secretive, any orders that are made are not. And really those 3 represent the principal amendments or the important amendments which were accepted by the government.
Yes, and if I may say as well, I think when people hear about this legislation, they automatically think property in terms of land in particular. But this legislation actually takes into account a range of assets and properties as well. Could you tell us more about that?
Yes, absolutely. It's an asset forfeiture, and you're absolutely right. It refers not just to property ownership, but anything which could be considered an asset. We are aware that the principal forms of assets are property, meaning land or land-related. The second would be, if you like, monies in the bank or monies which are kept in various financial institutions, and that also can be attacked now. But the third component is equally important, which is things like stocks, shares, bonds, annuities, investments of any kind which are tangible in character are fair game to the board, to the agency now. Things like motor vehicles, chattels, for instance, pictures, paintings, heirlooms, anything which on the face of it has a monetary value. Because bearing in mind that forfeiture means that the state is not going to hold on to these things, but rather that it will sell these items, then these things are fair game. So just to summarize in terms of the significance of the forfeiture provisions, it means that assuming that the High Court makes an order directing forfeiture of specific assets, then once that forfeiture order is made, then the government has the power and the authority to go into the various, let's say, financial institutions with a copy of the order and in effect demand, and this demand will be acceded to, that this particular asset be redirected into a government account or be transferred or assigned to the government. And the likelihood is that if the asset itself is a property or something which is non-monetary, that asset very much, for instance, in terms of levy actions, is likely to be sold, and the sums or the proceeds of the sale, less the cost of the sale, will then be credited to the government. So it means quite possibly that someone can purchase the asset, and therefore, if you like, by purchasing the asset, it means in effect that you are now liquidating the asset for the purposes of the government. So it's a very wide and extremely wide order, but it also means as well that since criminal activity or the wealth which is derived from criminal activity is generally not assets which are easily accessible, but are generally hidden through layers of families or friends or relatives, then one of the significant things is whether these orders can be traced or these properties can be traced. That has not been answered in the legislation. It speaks to assets which are owned or held by the person who is the subject of the forfeiture order. But having regard to the nature of civil activity, there is nothing to stop a government from, in effect, asking the High Court to make a tracing order, whereupon the court has the power to determine whether or not property which is, for instance, in a third party's name was in fact transferred or assigned to that person as merely a sham transaction to disguise the fact that it was really held by the person, the applicant, if you like. I hope that helps a little bit.
It does help a lot. And my final question, you touched on it actually, in terms of what's going to happen to those assets and properties that have been seized and I guess would eventually go to the government under this legislation. Does the legislation outline the method of sale?
I don't think I have studied the bill, but I haven't studied the amendments. But my preliminary review says that it doesn't. But it's no different from any other forfeiture order that is made by the state. Since the state is not in the business of owning properties or holding properties or motor vehicles, then the likelihood is that it's going to be reduced to a sale and the proceeds divided. But if I could just make this equally important point, or 2 points rather. The first one is that once an application is made, the onus of proof shifts from, in this case, the state or the agency to the person or to the respondent to prove, if you like, that the wealth was lawfully obtained. In other words, that there is a general shift in the burden, so that ordinarily, if I'm the Attorney General and I'm applying for an order, the onus is on me to prove that it was acquired through criminal activity. But when you read the provision, it suggests that the burden may shift, and the burden may now go to the person whose property is under attack to prove that it was not acquired through criminal activity. I think that's a very significant development, because it does constitute, if correct, a shift in the general burden of proof. The second point I just wanted to highlight very quickly is that, assuming that the person against whom the application has sought has since died or is in fact dead, that does not stop the state from going after the asset, because the application can be directed to the estate of the person against whom the order is exercisable. And the third point I just wanted to make, and this is important, because one imagines the narrative is that many of the assets which are acquired through ill-gotten means are generally sitting overseas, whether in accounts or bank accounts or properties which are elsewhere. The extraterritoriality of the legislation permits the Attorney General, and Section 65 of the bill makes this clear, to enter into agreements with foreign states for the seizure of property or assets which have been identified for forfeiture in the application. These things are fairly common. It provides for reciprocal arrangements, so that, I'll give an example, Trinidad and Tobago can enter into an agreement with the United States, or at least some of the states in the United States, for reciprocal orders, so that where an order is obtained locally, but relating to property which may be in Florida or New York or elsewhere, that order can be enforced in those states based on this agreement, and the proceeds from the sale can be repatriated to Trinidad. In other words, the idea of moving your assets abroad, if it is obtained through criminal activity, will not stop the state, provided that there is in fact an agreement between the states for the recovery of the assets. Good. Those are the points I wanted to highlight, Sarah.
Yes, very interesting. This is actually my final question now. You said you've perused the initial piece of legislation, and you are a bit familiar with the amendments. I know certain amendments have been more focused on than others, because quite a few were included when that vote was taken on Monday. Are there any particular loopholes or maybe weaknesses in the legislation that you've identified that you would like to see addressed?
It's a good point. Now, I haven't seen the revised bill as a result of the amendments, and you're right, we've only identified 3 or 4 of them. I feel that one of the main concerns, and certainly the Law Association has drawn this to the attention of the general community. And let me say for the record that while I'm a senior council member, I am not speaking on behalf of the Law Association. But having said that, I want to make the point that it is important that this process be insulated from political interference, and that has been something which has been, I think, part of the discussions from the opposition. Now, all of this is relevant because the agency that has statutory responsibility for conducting an investigation and making recommendations to the DPP comprise 3 specific groups. The first one is called the Civil Asset Trustee and Deputies, which is an individual or a group. And then, of course, we have one of the deputies is also an attorney at law appointed by the Judicial and Legal Service Commission. And the third person will be appointed following an agreement between the Prime Minister and the Leader of the Opposition. And in the absence of there being an agreement as to the third person, the President will make that appointment. Now, I believe that is significant because it does provide some sort of buffer for against political interference, because you have, on the face of it, independent agents who, in effect, have have an independence in order to shield them from ministerial and other interventions. The trustee, for instance, will be immune from criminal and civil actions. So that is one aspect of the insulation, but then it goes to the High Court, where, of course, our judges are immune from political interference. So that provides a second buffer. I think that what I've highlighted is actually a strength rather than a weakness. In terms of weaknesses, it's common with all the other, or most of the other legislation in Trinidad and Tobago, where this particular legislation, in fact, already exists. So this jurisdiction, to some extent, already exists since 2002 in terms of our existing legislation, which is the, I believe it's the Criminal Proceedings Act, does already make provision, and quite specifically the Proceeds of Crime Act. In other words, the Proceeds of Crime Act, which is a 2002 legislation, already makes provision for wealth, if you like, or assets derived from criminal activity to be the subject of forfeiture. So, to some extent, we now have first world legislation, quite direct legislation, but really in a third world arena of enforcement. And I think the biggest bugbear for me, and I suspect many practitioners, is whether or not this will be enforceable in a meaningful way to ensure that the mischief of the act, which is to remove wealth from criminal activity, actually takes place. And that really highlights my main concern with the legislation.
Well, thank you so much again, Mr. Ronnie Bissessar, Attorney at Law, joining us today to tell us more about the Civil Asset Recovery and Management and Unexplained Wealth Bill 2019, or as he and a lot of other people are referring to it in the interest of brevity, the Wealth Bill 2019. Thank you so much again, Mr. Bissessar, for your clarification. I'm sure it helped a lot of people who were, basically uncertain as to what this legislation actually means for them and for other people in this country.
Thank you very much for having me, Sarah.